I just watched my video on the rights of Tommy Robinson being violated his rights under the European Convention on Human Rights, and I realized that I've done a poor job explaining the duty to give reasons, because all the argumentation around Article 6 of the Convention and this refusal of the administration of the prison to allow a visitor to Tommy Robinson, all of it revolves around the duty to give reasons. The duty to give reasons is part of the procedure. If this duty is violated, that's a procedural violation. And usually the procedural violations in the Hollywood movies are dismissed as technicalities, as though it's some formality, something that doesn't really matter, but the lawyers being lawyers, they come with this stuff so that they could earn money and manipulate and all of that. You know, the Hollywood movies, the usual cliches. And people find it hard to understand what's the significance of this duty to give reasons. So the administrative body didn't give reasons, so what? Or factual reasons, legal reasons, what's the difference? Who cares? Well, actually, it is key to understanding how the law works. The difference between the significance of giving reasons and the difference between factual and legal reasons. And I'll try to explain it once more, hopefully this time better. The legal reasons and the factual reasons are just two sides of the same coin. Yes, by legal reasons we mean quoting some legal source, like I said, paragraph such and such, article such and such, from Act of Parliament such and such. And the factual reasons, that would be the facts that whoever issues this administrative refusal, in this case the letter which refuses a visit to Tommy Robinson, which facts the administration of the prison thinks are relevant, which facts the administration of the prison thinks are established. And why I say that these are just the two sides of the same thing? They are just like theory and evidence, or theory and facts. Because a theory that is not supported by any evidence is just some mental exercise which is pointless. It's not really a theory, it has nothing to do with, say, science. And facts without a theory are meaningless as well. I mean, we don't understand the connection between those facts. We don't understand their significance. So it's the uniting of the two. And actually, the theory, when you think of it, is just finding a logical causal connection between certain facts. And the same applies for the law. I mean, I was trying to explain how things are here in science, but in the law, the logic is exactly the same. So imagine the legal source, which is quoted, the legal norm, as the theory. And the facts match this theory, match this legal norm. So obviously, if we are talking about somebody, a YouTuber, being allowed to visit Tommy Robinson, there must be facts that, not just any facts, not just facts like tomorrow it will rain, or today the temperature is 3 degrees, or the fact that, for example, the corridor of a prison is painted, say, green. None of this matters. What are the facts that matter under the legal norm? And the legal norm in this case should be Article 10 of the European Convention on Human Rights. Because Britain doesn't have a constitution. So we cannot, like the Americans, open the American Constitution and see, First Amendment. Here it is. We don't have this in Britain. So what we have is Article 10 of the European Convention on Human Rights. And therefore, the reasons, the factual reasons in the letter with which the administration of the prison refuses, so that this letter is in accordance with the law, must contain some facts that are relevant under Article 10. Say facts that show that if Tommy Robinson is allowed to speak to a YouTuber, and then this is published on a YouTube channel, this will say endanger the national security of Britain, or the territorial integrity of Britain, or something else which is mentioned in Article 10. So the facts, they're just not any facts. They're the facts that are deemed relevant under the law. And the law, again, is not just any law. It is the law applicable to those facts. And therefore I say that factual reasons and legal reasons are just two aspects of the same thing. For the administration to make the case, it needs to state facts that are relevant. Say, Tommy Robinson knows something or will say something that will blah blah blah. And a legal norm, a legal source. Those two make a case. See, by making a case, the lawyers mean two things that must be there simultaneously: facts and legal source. And they must match. If there is a mismatch, there is no case. I mean, imagine somebody tries to make the case that Tommy Robinson must be refused a visit because, say, Tommy Robinson's weight is 100 kilos. Okay, his weight may as well be 100 kilos, but what this has to do with anything? And this is the impression I'm left with when I read this letter I mentioned in the video about Tommy Robinson. I don't see the connection. I don't see, even if there was a legal source quoted, even if there were legal reasons there, and there are none, but even if there were, and even if there was Article 10, I assume it must be Article 10, because what else? There is nothing above Article 10. I mean, sure, the prison could have some policy, but it doesn't trump the European Convention on Human Rights. The European Convention on Human Rights is above everything else. So I'm trying to imagine that Article 10 is quoted, although it's not. Article 10, paragraph 2, I mean, where the exceptions, where the grounds for limiting one's freedom of expression are listed. Even if it's quoted, what the letter says doesn't add up. It's not connected. There is a disconnect. It simply says that they refuse the visitation because they expect that the information given by Tommy will end up on YouTube, on some YouTube channel. So what? Where's the connection? Does this mean it's endangering the national security of Britain? And how? I mean, this is the thing that people don't understand. And when somebody this usually in the Hollywood movies, usually they revolve around some criminal trial, because there is more drama there. They rarely revolve around administrative procedures, but the logic is the same. I mean, you have to make the case in a civil case, you make the case in an administrative case, you must make the case in a criminal case. And making the case always means the same thing: this unity of established facts and quoted legal sources. One of the two is never enough. I mean, for example, there may be some horrible facts. Somebody is immoral, somebody is a despicable human being, whatever. As long as there is no legal source that says that this matters and there are legal consequences, it is irrelevant. And the same logic applies if we have a legal source without established facts. Okay, maybe there is a legal source that says that Tommy Robinson should not be allowed visitors. Okay, actually there is no such legal source, but let's, for the sake of argument, imagine that there was. As long as there are no facts that I cannot find, I'm sorry, the English is not my mother tongue, I cannot find the right words. As long as there are no relevant facts that lead to the application of this legal source, again, it's irrelevant. There must be facts and legal sources, factual and legal reasons, and they must match. It must be a match made in heaven. Otherwise, we don't have reasons. And this opens the door to the administration abusing its powers. It opens the door to the administration basically being unconstrained by law. And this is why in countries with rule of law, there is this rule that the administration, the administrative body, this is what I mean by administration, not the process, but the institution, that the institution must give reasons, because this duty to give reasons constrains those in power. They cannot do whatever they feel like it. They're constrained by the law and by the facts. If they don't have evidence and if they don't have a legal source, they cannot do whatever they like. And this is the problem with the British law, because the British law, like I said in the other video, has specific occasions when it obliges the administration to the administrative body to give reasons, but there is no general rule, which means that whenever there is not such a specific norm in some act of parliament, say, or case law, which says on this occasion they must give reasons, they don't give reasons. And if they don't give reasons, we don't understand what is going on. They're unconstrained. There is no transparency. Eventually, there is no accountability. They become our masters. We are not the masters of them. They are the masters of us. This is why I say that the British law is actually backward, because the British law, unlike the legal systems on the continent, doesn't have this duty to give reasons. That's a duty on those in power, to give reasons. And this letter that I quoted in the other video is a perfect illustration of this. Well, please let me know if I'm still not explaining it clearly. I need feedback in order to know. Because to me it's kind of obvious, but I see the situation through the prism of being a former lawyer who has made a career in this field And what is obvious to me is far from obvious to others. I know this from the reactions of, say, my girlfriend, because when she sees a Hollywood movie where the person charged, in her mind, that's the criminal. When the person charged is let go just because of some technicality, she is not happy. And actually, technicalities matter. Technicalities are what prevent those in power to enslave us. And this is why Britain the West is civilized, and say Russia or China are not. Because in Russia or China, the authorities could do whatever they feel like it. Oh, that's it. Enough of a rant for today.